My name is Malcolm Langford. I'm an associate professor at the University of Oslo. I'm a lawyer and an economist. I'm also the director of the Centre for Law and Social Transformation at the University of Bergen and Christian Michelsen Institute.
And how do you perceive the relationship between the economic crisis and human rights protection?
I think it's important to avoid sort of extreme positions in thinking either about austerity measures and economic recession and human rights. For the first, I think human rights has a great respect for democratic processes. And that means, we should first look to parliaments and public debate as an arena in which to address problems of the recession responses, the types of macroeconomic and microeconomic policies that may follow. And I think that's important for two reasons. One, public deliberations allow lots of information, knowledge to come out, and debates and trade-offs to be discussed. Secondly, it allows interest groups to form and to mobilise and to lobby for their particular interests. And so when it comes to, for example, cuts to various social rights, we would hope that various coalitions would form that would defend the interests of those most affected so that their voice would be heard in those democratic processes. However, I think human rights specifically has something very much to contribute because democracy has sort of two weaknesses. So that the first is what happens when those sectarian interests, those forces mobilising politically, don't represent particular and vulnerable interests. Okay, and that we think particularly about. We might think about poorer groups. We might think about ethnic minorities. We might think about women's interests that may not be defended by the organised groups, which may be trade unions or doctors or whoever they may be. And so, therefore, we need to be particularly sensitive to those interests in the process. And that should happen in Parliament. It should happen in the executive, but it also provides a role for courts as well, to make sure that those interests are particularly protected. I think human rights also provides an analytical frame which is different, say, than some of the sort of deliberative processes that you might see in a parliament. It's clear about the standards, for example, of cutbacks to various social rights. So I was a consultant for the Office of the High Commissioner for Human Rights in 2007 and involved in the drafting of the General Comment on the Right to Social Security, for example, which really sets out a template for how to think about retrogressive measures. So it's not an absolute framework. Governments are able to cut back on budgets, cut back on social spending, and sometimes there may be some very good reasons for that. But it provides you a template in which to analyse the reasons behind it and the justification. And some of those include, does it take individuals or certain groups below a certain threshold, a minimum core? Does it discriminate? Has there been sufficient deliberation around the various trade-offs and interests which are affected? Is it a long-term measure or is this a short-term temporary measure? Has this measure been evaluated by some independent mechanism which may be more insulated from political interest, and so forth? So these sorts of principles, I think, provide a very useful analytical frame for thinking about retrogressive measures. It's essentially a proportionality test. The other aspect where national democracies often struggle is in their relationship with international actors, okay? And so in the context of many sort of recessions in the last 30 or 40 years, international lenders are a key part of the picture. And so countries often go to international lenders to get short-term financing in order to either cover a budget deficit, cover existing loans, or to engage in some sort of expansionary social spending, or in the case of the recent crisis, to save banks for better or worse. And the key issue is the conditions that those international lenders address. And those international lenders don't deal with parliaments, they don't deal with courts, they don't deal with the publics, they deal with executives. Executives have incredible power in that context. And parliaments have very limited control usually over foreign policy. They tend not to ratify treaties. That's an executive matter. And therefore you need some sort of scrutiny of these relationships between international lenders and executives. And executives are making commitments that have consequences for 20, 30 years if you're paying off that debt. Or you're signing on conditions, for example, that might require drastic cutbacks in areas like education, health or social security. Or you're signing on to conditions that require privatisation, which may affect the affordability of water, education and healthcare. And therefore I think human rights provides a useful template to analyse those relationships, but also to see that international donors carry extraterritorial human rights obligations, that they need to take into account what they are doing in those negotiations. And likewise the domestic executives need to take into account their human rights obligations in those discussions.
Okay, thank you very much. And in the context of the discussions between austerity measures and human rights, you have developed quite an impressive expertise on the special case of Latvia and on the courts and on the jurisprudence applicable there. May I ask you to explain a bit why you see this as a model?
Well, I think it's an interesting model in actually representing all the issues I just talked about. So Latvia is firstly a special case. It had the largest contraction in GDP in 2007 and 2008. In a 2-year period, its gross domestic product was reduced by 25%. Okay? So it's a massive reduction in its sort of economic base. Secondly, it engaged in a range of sort of macroeconomic measures, including cuts to social security and massive cuts to public sector wages. So austerity measures were strong, and they were also front-loaded. So in some countries you phase them over a period. In Latvia they were pretty much front-loaded in 2 years in budgets that were passed in 2008 and 2009. The third thing is that Latvia is praised by many economists as a model of how to respond to an economic crisis. And the reason for this is that Latvia had the highest economic growth rates from 2009 onwards. So it came out of the recession faster than other countries compared to, say, Iceland or Ireland or the southern European countries. But fourthly, Latvia is interesting because one of those measures was challenged before the Constitutional Court. And you would think that this would be a very difficult issue for a Constitutional Court to deal with. Things are happening very rapidly. You've got a massive fall in GDP. You might ask, what do courts know about economic matters, about balancing economic efficiency and social protection? And how could they deal with it in such a short period of time? Given that a budget was passed, for example, in June 2009, and it's meant to go into effect in 5 or 6 months. But what the Latvian Constitutional Court does in that context is to respond in a very reflexive and rapid manner. So it finds that the case is admissible, and the case is brought by the minority in Parliament who lost the vote on the budget, plus some other actors. The second thing is that it summoned 17 different actors to provide extra information, submissions to the court on the background to the cuts, the economic justifications, the social consequences, so that it could look at the full range of sort of information available, but also engage in a participatory exercise in itself, a form of democracy, but perhaps a more reasoned, and possibly rational approach to deliberation in this case. And so the actors included the Treasury, the Ministry of Finance, an ombudsman, the trade unions, the employers, two human rights experts, a finance expert. And then on the basis of that, it moved to its decision. And it said, on one hand, the government has a lot of freedom in cases like this. Okay, that you have to give the government space in determining what are its maximum available resources, what is its space in responding to a crisis. On the other hand, right to social security was affected. The right to social security was incorporated in the Latvian constitution through the International Covenant on Economic and Social Rights, and the courts were mandated to monitor and enforce that right. And so the court applies a proportionality test and says, well, does the government have a legitimate aim? Yes, it does. It's trying to address a crisis. But were the measures adopted proportional to that aim? And here comes in the human rights requirements that I was talking about earlier. And the court says no, it wasn't proportional. And there's two aspects of the judgment which are particularly interesting. The first, it says it will take some pensioners significantly below the minimum core. So already there was evidence, ironically enough, from the international financial institutions, that the current level of pensions was below sort of a minimum required. And therefore a cut of 10% to existing pensions and a cut of 70% for pensions for people who are also working would take a significant group of people below the minimum core. The second thing that the court finds is that it was essentially arbitrary. And here comes the politics into it. And here you find a court that's able to see that through the formal economic grounds to the politics that lies behind who has to bear the burden of austerity measures. Because what the court says is, hey, there's a universal child benefit which all families get. And this universal child benefit was only introduced a year before the crisis. It was actually introduced without any revenue measure behind it. So it's taking funding from the social insurance and social pension system. And it was left fully protected during the cuts. And so all families can therefore continue to receive this benefit, whether they're rich or poor. But poor pensioners were left with the majority of the cuts. The court doesn't say this, but what it's effectively saying is that politics is behind this. And if you look at Latvian politics, it's heavily ethnicised. You have a group of centre-right parties that compete for an ethnically Latvian middle. And one of the ways they do this is to partly marginalise the Russian ethnic minority, which is not represented in these parties. And what the mix of these measures would do is the burdens would mostly fall on the poorer ethnic Russians, who are more likely to be pensioners because they often have higher rates of unemployment. Yet the child benefit would be maintained for middle-class ethnic Latvian families. And so what the court does through this process of applying human rights template, of bringing information, is to say it doesn't seem that the economic grounds are really driving this, it's actually political. And in doing so, they give voice to a marginalised group which is effectively excluded from Latvian politics. So here you see the democratic role of the court. Two other interesting points about the Latvian judgment. It examines the relationship between the Latvian government and the EU and the IMF. Because one of the reasons why the Latvian government said we needed to cut pensions was pressure from the IMF and the European Union in the loans that they were giving, that these cuts were part of the conditions that were required. But when the court went through the evidence, it couldn't find these demands. The European Union and the IMF had said there needs to be fiscal consolidation, but they didn't point out that pensions were precisely to be attacked. So they basically reveal the dangers of national governments sort of interpreting also the conditions and not properly standing up for social rights in their negotiations with international donors. The other interesting thing to ask about this whole Latvian story is what happened afterwards. Did the Latvian constitution get it right? Did the intervention or the introduction of a human rights perspective mess things up economically? Because that's the fear of economists, that if you come in and you start protecting different parts of the budget, then the credit markets will be restrained, you won't see economic growth emerging, the cuts will have to come from somewhere else if they don't come from the designated areas of the government. But what happened in Latvia? Well, looking at all the economic evidence, it's not clear that the fiscal austerity measures were the reason why Latvia recovered so quickly. Other measures seem to be much more important in getting Latvia back on its feet, and that include some measures in protecting some of the banks, but particularly the Nordic banks, propping up the system in Latvia. Its internal devaluation may have improved its productivity levels, but also its fiscal cutbacks were so strong that they actually threatened to undermine domestic demand in the country. And so it's arguable that the court actually helped the recovery by stopping the government cutting too much. And that actually helped domestic demand. It actually helped the economy to move on because the government didn't cut another area of the budget.
Thank you very much. This was very interesting. May I ask you one last question? Based on your expertise, how would you see that the EU could perhaps overcome these issues and more particularly strengthen the protection of social and economic rights in the particular context of austerity measures?
I think it's important to recognise two things. We'll begin with two assumptions. The first is that in realising social rights, the overall level of the budget is not necessarily critical. Okay? So we have countries in Europe with similar levels of taxation, but with very different outcomes in terms of addressing poverty and inequality. So if you compare, for example, the Nordic states with some of the southern European states. And so the trick is, in my view, is to get a virtuous cycle of growth and equity or social rights, to get the right mix of regulation and social spending. So I think that when the European Union engages in discussions with member states over social policy or it's imposing loan conditions, they need to be sensitive to the lessons learned in this right balance. Sometimes, social spending will need to be cut in some areas. Sometimes there will need to be deregulation, maybe even privatisation in some areas. But one needs to learn, I think, from those countries which are able to balance that in the best way, such that you do get positive social rights outcomes. The second thing I think the European Union needs to acknowledge, and particularly the major powers behind the European Union, is their own contribution to these crises. Their own provision of loans earlier on, for example, for military spending in some of the countries which are going through particular crises. The European Union has also maintained a very low interest rate for the last decade, which has led to a lot of spending. And so I think one should perhaps think about Thomas Pogge's approach of institutional cosmopolitanism, where stronger states, major powers, acknowledge their own contribution to the global basic structure and the way in which it can lead to suboptimal human rights outcomes. And so I think that's a very important starting point, is to begin with some humility in the process, and to acknowledge the historical backdrop before you start to, and your own responsibility, before you start to lecture other countries about how they should reform their processes. And so obviously you have major debates around in Greece and in Portugal and Italy about the conditions that the European Union and IMF have been imposing. But I think that's what I see as lacking in these particular debates.
Thank you very much.
You're welcome.